In this video, we'll be talking about important MCQs on Hindu law. These MCQs with explanation will be very helpful for LLB students. So let us start. The first question: which out of the following is not modern source of Hindu law? Equity, justice and good conscience, precedent, legislation and custom. Equity, justice and good conscience, it is a source of Hindu law. Precedents, मतलब पहले जो घटनाएं हो चुकी है, that is also a precedent. That is also a source of Hindu law. Legislation is also a Hindu law. This custom is not a source of Hindu law. Custom is the answer. Next question: the ancient sources of Hindu law are Shruti, Smriti, digest, commentaries and custom, all of the above. Shruti, Smriti, digest, commentaries and custom, all of these are sources of Hindu law. So answer should be all of the above. Who is a Hindu among the following? A legitimate child of Sikh male and Jain female, an illegitimate child of Sikh male and Jain female, an illegitimate child of Hindu male and Parsi female, and who was brought up as a Hindu, or all of the above. The answer is all of the above. Sikh male and Jain female, they are reckoned as Hindu. Sikh male and Jain female is also Hindu. Hindu male and Parsi female are also Hindu. Under section 2 of the Hindus Marriage Act, explanation A and B states that all these are Hindus. So all of the above will be the correct answer. A child, whether legitimate or illegitimate, they are reckoned as Hindu if they are born in a family of this Hindu Sikh male and Jain female, Sikh male and Jain female, whether legitimate or illegitimate, that doesn't matter. A legitimate child or illegitimate child, that also doesn't matter in case of Hindu male and Parsi female, and who was brought up as a Hindu. So all of the above is the correct answer. Sapinda relationship. Sapinda relationship extends up to 4th generation through mother, 5th generation through mother, 3rd generation through mother, or none of the above. Through mother, it is 3rd generation through mother, and 5th generation through father. It is defined under section 3 of Hindu Marriage Act. 3 subclause F, subclause 1. So Sapinda relationship extends up to 3rd generation through mother, and through father it is 5th generation. So C is the correct answer. Under the Constitution of India, all aspects of family law are provided in the Union list, state list, or concurrent list, none of the above. Under the Constitution of India, all aspects of family law are provided in concurrent list. In this, both state and union can take action or make laws. This is under concurrent list. The Hindu Marriage Act 1955 came into force on 1st January 1955, 1st May 1955, 26th of January 1955, or 18th of May 1955. Hindu Marriage Act 1955, it came into effect from 18th of May 1955. Very important question. Hindu Marriage Act 1955 came into force on 18th of May 1955. Hindu law is a civil law, personal law, constitutional law, or criminal law. It is a personal law. Hindu law is a personal law. Which of the following is school of Hindu law? Mitakshara, Dayabhaga, both A and B, or none of these? It should be both A and B. Mitakshara and Dayabhaga both are school of Hindu law. Hindu law is not applicable in which of the following cases? A person who is a Hindu, Jain, Sikh, or Buddhist by religion. Hindu law is not applicable. Not applicable in which of the following cases? A person who is a Hindu, Jain, Sikh, or Buddhist by religion, it is applicable to these people. If any person who is born of Hindu parents, this law is applicable to them also. Any person who is not a Muslim, Christian, Parsi, or Jew, it is also applicable to them. A person who is not a Muslim, that means a person is of some other religion than Muslim, Christian, Parsi, or Jew. This law is not applicable to these persons, Muslim, Christian, Parsi, or Jew. Members of the scheduled tribes coming within clause 25 of the article 366 of the Constitution of India. This law is not applicable to any scheduled tribes coming within clause 25 of article 366 of the Constitution of India. Hindu, Jain, Sikh, Buddhist, it is applicable to them. Person who is born Hindu, applicable. A person who is not a Muslim, Christian, Parsi, or Jew, this law is applicable to them also. Because to Muslim, this law is not applicable. To Christian, this law is not applicable. To Parsi, this law is not applicable. Or to Jew, this law is not applicable. So, the option is a person who is not a Muslim. So, this law is not applicable to the members of scheduled tribes coming within clause 25 of article 366 of Constitution of India. Law relating to marriages amongst Hindus has been codified under the Hindu Marriage Act 1955, Hindu Adoption and Maintenance Act 1956, Child Marriage Restraint Act 1929, or all of the above. It is Hindu marriages amongst. This is codified under the Hindu Marriage Act 1955. Marriages amongst Hindus. It is under Hindu Marriage Act 1955. Degrees of prohibited relationship include relationship by full blood, half or uterine blood, adoption, or all of the above. It is all of the above under section 3 subclause G of the Hindu Marriage Act. This comes full blood, half or uterine blood, adoption, all this comes under prohibited degrees. So all of the above is the correct answer. A married B, but the marriage was void for being within the prohibited degrees of relationship. After some time, A married C, while B was still living with him. A's marriage to C is valid, voidable at the option of C, void, or valid but punishable. It is a valid marriage. A married B, but the marriage was void. It is void. That is, this marriage is not considered as valid. If not considered as valid, that means A is unmarried for being within the prohibited degrees of relationship. After some time, A married C. After some time, A married C, while B was still living with him. This marriage was void. So, whether she is living with him or not living with him is not the question here. Totally, the marriage is void. That means no marriage has taken place. So, A has married C again after a few days or some time. A's marriage to C is valid. It is a valid marriage. Option A is correct. Sapinda relationship includes relationship by half or uterine blood, full blood, adoption, all of the above. It is all of the above. Under section 3G of Hindu Marriage Act 1955. Sapinda relationship includes half or uterine blood, full blood, adoption. Degrees of prohibited relationship include relationship by full blood. It is all of the. This is repeated question, I feel. Okay. Which one of the following is not included in the term of Hindu used in Hindu Marriage Act 1955? Sikhs, Jains, Parsis, or Buddhist? Parsis are not included in the term of Hindu used in Hindu marriage. Parsis are not included. Definition of this Hindu is provided under section 2 of Hindu Marriage Act 1955. Parsis are not included in the term Hindu used in Hindu Marriage Act 1955. The Hindu Marriage Act 1955 is applicable to A Jain and B, a Buddhist, both having domicile in Sikkim and working in United Kingdom. C, a Sikh, and D, a Hindu, both having domicile in United Kingdom and working in Sri Lanka. No. G and H, both Hindus having domicile in Bhutan and working in United Kingdom. This is not applicable to them. But A Jain and B Buddhist, both having domicile in Sikkim, that is in India, and working in United Kingdom. No issue. But they are domicile of Sikkim, that is India. Therefore, this law is applicable to them only. Indian citizen, those who are living outside the country, this law is applicable to them also. The Hindu Marriage Act extends to the whole of India, Buddhist and Jains, those who are not Muslims, Christians, Parsis, Jews by religion, or all of the above. This law is applicable to all of the above. The whole of India, it is applicable. Buddhist and Jains also it is applicable. Those who are not Muslims, that is some other religion, Christian, Parsis, and Jews by religion, this law is applicable to them also. And so the answer should be all of the. Under Hindu Marriage Act, Hindu includes Buddhist, yes. Sikh, yes. Jain, it is also yes. Buddhist, Sikh, Jain, they are included in Hindu. So all of the above is the correct answer. Which one of the following statement is not correct? Hindu Marriage Act applies to Jains, Buddhist, Sikhs, person belonging to scheduled tribe. Is not correct. So persons belonging to scheduled tribe, this law is not applicable to scheduled tribes coming under clause 25 of article 366 of Indian Constitution. This law is not applicable to person belonging to scheduled tribe. The Hindu Marriage Act 1955 is not applicable to a follower of the Brahma Samaj, the person who is a Sikh by religion, any person who is a convert to the Hindu religion, the member of any scheduled tribe. It is very simple. This law is not applicable to any scheduled tribe. This is the correct answer. A Hindu may be Buddhist, Jain, Arya Samaji, or all of the above. Yes. A Hindu may be Buddhist, Jain, or Arya Samaji. It is all of the above. Hindu law does not apply to a person who is a Hindu by birth, conversion, reconversion, or none of the above. By birth, if a person is Hindu by birth, this law is applicable. If someone has converted to Hindu, this law is applicable to them also. If someone has, suppose he was Hindu, converted to Muslim, again he has converted to Hindu. So, reconversion, this is applicable to this person also. So, none of the above option is correct. Hindu law does not apply to a person who is a Hindu by birth, conversion, reconversion. This law is applicable to all of these classes. So, none of these is the correct answer. In Hindu Marriage Act 1955, degrees of prohibited relationship is defined under Section 3B, 3G, 3E or 3E or 3G. It is under Section 3G. Degrees of prohibited relationship is defined under Section 3G of Hindu's Marriage Act 1955. Section 3B, it is talking about district court. Section 3, it is in this section all the definitions are given, and in Section 3 clause E, it definition of prescribed is given. So under Section 3 clause G of Hindu's Marriage Act, degrees of prohibited relationship is defined. D is the correct answer. Which out of the following is not a Hindu under the Hindu Marriage Act 1955? A legitimate child whose father is a Hindu and a mother a Parsi, and he is brought up as a family member of the latter, that is Parsi. An illegitimate child whose father is Sikh and mother a Buddhist, a reconvert by Buddhism, a Virashabya by religion. This law is not applicable to illegitimate child whose father is a Hindu and a mother a Parsi, but he is brought up as a Parsi. So they are not falling under the definition of Hindu. So this law will not be applicable to them. A Hindu father and a Parsi mother, but brought up as a family member of the Parsi. A is the correct answer. After the institution of suit for partition by a member of the joint family, there is no effect in the shares by virtue of births and deaths. Subsequent births in the family diminish the share. Subsequent deaths in the family augment the share. Suppose a suit for partition by a member, joint member. 5 members were there, A, B, C, D, and E. They have filed a suit for partition. And after filing this suit, a member is increased. A, B, C, D, E, F. There is no effect in the shares by virtue of births and deaths. Subsequent births in the family diminishes the share, or subsequent deaths in the family augment the share. No, there is no effect in the shares by virtue of birth or death. If the member increases also, there will be no diminution, and if the member decreases by subsequent deaths, our 5 members were there, now he has died, so there will be 4 members. If 4 members, then there will be augmentation of the share. So these both options are wrong. There will be no effect in shares by virtue of births and deaths. This will be divided among these initial 5 people when the institution of suit for partition was initiated. So A is the correct answer. A Hindu ceases to be a Hindu by renunciation, abandonment, conversion, or neither of these. A Hindu ceases to be a Hindu by conversion. Suppose he was a Hindu, he has converted to Muslim. He ceases to be a Hindu. So conversion is the correct answer. A Hindu girl wishes to marry her mother's sister's adopted Hindu son, who happens to be her childhood friend since the pre-adoption days. Such a marriage under Hindu law will be valid, prohibited degree of relationship, voidable, or none of this. It is prohibited degree of relationship. Adoption is also coming under prohibited degree of relationship. A joint Hindu family consists of all persons descended from a common ancestor and their unmarried daughters. All Hindu lineally descended from a common ancestor. All persons lineally descended from a common ancestor, including their wives but excluding their unmarried daughter. All persons lineally descended from a common ancestor, including their wives and unmarried daughter. A joint Hindu family consists of all persons lineally descended from a common ancestor, including their wives and unmarried daughter. This is the correct answer. Section 30 of Hindu Succession Act 1956 authorizes a Hindu to dispose of by will his self-acquired property, undivided share in the Mitakshara Parsinary property, both A and B, only A and not B. It is both A and B. Section 30 of the Hindu Succession Act 1956 authorizes a Hindu to dispose all his self-acquired property and undivided share in the Mitakshara Copercinary property. Both A and B is the correct answer. A born Christian girl brought up by a Hindu family married a Hindu boy as per Shastric ceremonies. The marriage is invalid, voidable at the option of girl, voidable at the option of boy. A born Christian girl brought up by a Hindu family married a Hindu boy as per Shastric ceremonies. The marriage is invalid. Christian girl brought up by a Hindu family, it is invalid. Marriage of a Hindu male with the widow of his brother is valid, voidable, void unless protected by custom or usage. Marriage of a Hindu male with the widow of his brother, this is the man and this is the widow of his brother. His brother has died. With the widow of his brother has died. If this man marries this woman, this will be valid, voidable or void unless protected by custom or uses. It is void. Instantly it is void unless it is protected by custom or uses. D is correct. This marriage will be void unless it is protected by custom or uses. The marriage of a Hindu man with the biological sister of his adopted sister is void, valid, voidable or illegal. It is void. Hindu man with the biological sister of his adopted sister will be void. Prohibited degree and subpoena relationships are mutually exclusive, dependent on each other, may overlap each other, or none of this. Prohibited degree and subpoena relationships may overlap each other. The correct answer, may overlap each other. When two persons are the descendants of a common ancestor, but by different wives, they are said to be related to each other by half blood, full blood, uterine blood, either B or C. Two persons are descendants of a common ancestor. A, B, and C. These are common ancestor A, but by different wives. A had two wives, D and E. B came from A and C came from D. They are said to be related to each other by half blood, full blood, uterine blood, or either B or C. It will be by half blood. is common, mother is different, D and E. It will be half blood. A Hindu male having undivided interest in a Mitakshara Koparsinari property dies leaving behind 2 sons and 1 daughter. The daughter is entitled to the following share in the property. It will be 1. Total how many persons are there? A having undivided interest in Mitakshara, leaving behind 2 sons and 1 daughter. 3. The share will be 1/3. The daughter is entitled to the following share in property by 1/3. Which of the following conditions is exempted if the custom governing each of the parties to a Hindu marriage so permits? Neither party has a spouse living at the time of the marriage. Neither party is incapable of giving a valid consent to the marriage. Bridegroom has completed the age of 21 years. The parties are not subpoenas to each other. Which of the following condition is exempted from the governing the marriage of Hindu marriage? So it permits that neither party has a spouse living at the time of marriage. If any person is having any spouse at the time of marriage, then that marriage becomes void. Neither party is incapable of giving a valid consent to the marriage. That marriage will be void. The bridegroom has completed the age of 20 years. The parties are not subpoenas to each other. This is the correct answer. Unless the custom or usage governing each of them permits of any marriage between the two, they are subpoenas. If any customs और रीति नीति कोई अगर ऐसा कुछ रूल्स हो कस्टम्स हो जिसमें ये मैरिज चले, then this would be not coming under this exemption, but the parties are not subpoenas of each other. This is a condition which is exempted if the custom governing each of the parties to a Hindu marriage so permits, then this marriage will be valid. A marriage under Hindu law between subpoenas parties shall be valid if the custom or usage governing each of them permits. If the custom or usage governing any of them permits, it will be if the custom or usage governing each of them, A is a party and B is a party. If the custom or usage is governing, that is, if the custom is allowing to A as well as B to initiate a marriage between these subpoena parties, then this will be a valid marriage. If the custom or usage governing any of them permits, no, both of them should permit, then the marriage will be a valid marriage. If parties to a Hindu marriage are subpoena to each other, the marriage is valid, voidable, void, none of this, it is void. If they are subpoena, then the marriage is void unless there is any customary permitting both the parties that they can initiate marriage between those relationships. A Hindu marriage may be solemnized according to the customary rites and ceremonies of bride, bridegroom, both the parties, either party, bride or bridegroom, thereto. It can be solemnized according to the customary rites of either of the party. Registration of marriage has been made compulsory by Hindu Marriage Act 1955 under section 10, 9, 8 or 12. It is under section 8. It is under section 8 of the Hindu Marriage Act. It is made compulsory that registration of the marriage has to be done. A Hindu marriage is a sacrament, a contract, a social function, recognition of the spouse as husband and wife. No, it is a sacrament. It is a holy relation. The marriage is a sacrament. A party is regarded as not having the mental capacity to solemnize the marriage if suffering from unsoundness of mind, mental disorder, insanity or epilepsy, or all of the above. It should be all of the above. Unsoundness of mind, mental disorder, insanity or epilepsy, all of the above. Under section 5 of Hindu Marriage Act, this marriage will be void. Epilepsy, this has been omitted by Act 39 of 1999 from this Hindu Marriage Act. Epilepsy omitted. So all of the above is the correct. Which one of the following acts has fixed the minimum age of marriage of boys and girls? The Child Marriage Restraint Act, the Hindu Marriage Act, the Special Marriage Act, all of the above. Under all these acts, the minimum age of marriage of boys and girls are fixed. So all of the above is the answer. Which one of the following sections of the Hindu Marriage Act 1955 provides conditions of marriage? Section 2, Section 3, 5 and 4. It should be Section 5. Conditions of marriage is provided under Section 5 of Hindu Marriage Act. Section 2, it is the applicability of Act. It provides the application of this Act. Section 3, all definitions are provided under this section. And Section 4, it is overriding effect of this Act is provided under this section. So Section 5 is correct answer, which provides the condition of marriage. Which of the following ceremonies are obligatory under Hindu Marriage Act 1955 for a valid marriage? Kanyadan, Saptapadi, customary rites and ceremonies of either party, or all of the above? Under Section 7, Clause 1 of Hindu Marriage Act, customary rites and ceremonies of either party is obligatory under Hindu Marriage Act. It is customary rites and ceremonies of any of the party. Can a Hindu marry second time on the basis of written consent of his first wife? No. No. Divorce has to be there. Written consent is not a divorce. They cannot marry. Marriage between a married man and an unmarried woman is voidable. None of this. Married man and an unmarried woman, it is void. Which of the following the prerequisite is not a ground for judicial separation of a marriage? Cruelty, bigamy, suffering from venereal disease, demand for dowry. Not a ground for judicial separation of marriage. Cruelty, it is a ground. Bigamy, suffering from venereal disease, all these are ground or for judicial separation of a marriage. But demand for dowry is not a prerequisite. Is not a ground for judicial separation of marriage under Section 10. It should be read with Section 13. Demand for dowry. This is the correct answer. Section 10. It should be read with Section 13. Which one of the following is not the ground of judicial separation under Section 10 of the Hindu Marriage Act 1955? Adultery, it is a ground. Cruelty is also a ground. Leprosy is also a ground. Missing for less than 7 years. Missing for less than 7 years. That is not a ground provided under Section 10 of the Hindu Marriage Act. Missing for less than 7 years. It should be read with Section 13, Clause 7. Missing for less than 7 years is the correct answer. Under Hindu law, if a minor marries without the consent of the parents or guardian, the marriage would be invalid, void, valid, both A and B. It would be valid. Under Hindu law, if a minor marries without the consent of the parents or guardian, the marriage would be valid. Without the consent of the parents or guardian, the marriage would be invalid, void, valid, both A and B. No, it will be valid. It will be valid. Adultery is a ground under Hindu Marriage Act 1955 for judicial separation, divorce, judicial separation and divorce both, only divorce and not judicial separation. No, it is judicial separation and divorce both. Adultery is a ground for both divorce and judicial separation as per section 10 and 13 of Hindu Marriage Act 1955. After the passing of a decree for judicial separation, cohabitation is obligatory, not obligatory, directory, either A and C. Decree for judicial separation, cohabitation is not obligatory. However, court can rescind this decree of application by on submission of application by a petition when party states function of the after passing the decree of judicial separation, cohabitation is not obligatory. But if an applicant or either of the party is submitting an application to the court, this court can rescind this order and direct them to cohabitate. But on the application of the party, it depends upon the permission granted by the court upon submission of application. Forced intercourse by a man with his wife while a decree of judicial separation is in effect is punishable under the Hindu Marriage Act, is punishable under the Indian Penal Code, is not an offense in India, or none of these. Forced intercourse by a man while a decree of judicial separation is in effect is a punishable offense under Indian Penal Code. In India, decree of restitution of conjugal rights can be executed by attachment of property of respondent, arrest of the respondent, either attachment of property or by arrest of respondent and fine, attachment of property and arrest of respondent both. Restitution of conjugal rights can be executed by attachment of the property of the respondent in India. The restitution of conjugal rights in a decree can be executed by attachment of property of the respondent. The Hindu Marriage Act 1955 contains the minimum period of desertion for filing a suit for judicial separation: 3 years, 5 years, 2 years, or 7 years. It is 2 years. This ground is mentioned in section 10 and 13 of the Hindu Marriage Act. The desertion for filing a suit for judicial separation, the minimum period should be 2 years. If during the period of judicial separation either spouse indulges in adultery, does it furnish a ground for divorce? Of course, yes. During the judicial separation, either spouse indulges in adultery, it is a ground for divorce. Yes. Restitution of conjugal rights can be claimed when there is a withdrawal from the society of other with an excuse when there is a withdrawal from the society of father without any reasonable excuse, when there is a withdrawal from the society of other without any absolute cause, or both A and B. It is rights can be claimed when there is a withdrawal from the society of other without any reasonable cause. A is married to B and B has withdrawal from the society without any sufficient cause, then A can claim restitution of conjugal rights under this clause. So B is the correct answer. Restitution of conjugal rights is available to wife, only husbands and not wife, wife and husband both, or husband. Conjugal rights, these are available to both wife and husband under section 9 of Hindu Marriage Act. Conjugal rights is available to both husband and wife. Remedy of restitution of conjugal rights is aimed at dissolving the marriage, preserving the marriage, both A and B. It is for preserving the marriage. Which one of the following sections of the Hindu Marriage Act provides restitution of conjugal rights? It is section 9. Section 9 provides the provision of restitution of conjugal rights. Section 5, it provides the conditions of a valid marriage, conditions of marriages, and section 10, it is judicial separation. Section 11 provides the provision for void marriages. Section 5 is provides the provision of conditions of marriages. Section 10, it is judicial separation, and section 11 is void marriages. So the restitution of conjugal rights, it is provided under section 9 of Hindu Marriage. A marriage solemnity between two Hindus would not be regarded as void under section 11 of the Hindu Marriage Act if one party has a spouse living at the time of marriage. Would not be regarded as void. One party has a spouse, no spouse living at the time of marriage, the marriage will be void. The parties are within the degree of prohibited relation, the marriage will be void. Either party is incapable of giving a valid consent to the marriage due to unsoundness of mind, or the parties are secondary to each other. This is the correct answer. Either party is incapable of giving a valid consent to the marriage due to unsoundness of mind. It is correct answer. A marriage solemnity between two Hindus would not be regarded as void under section 11 if either party is incapable of giving a valid consent to the marriage due to unsoundness of mind. This would not be a void. Where the wife files a petition for restitution of conjugal rights under section 9 of the Hindu Marriage Act, on whom lies the burden of proving reasonable excuse for withdrawal from the society. Petitioner wife, respondent husband, family members of the wife, family members of the husband. It would be the reasonable excuse for withdrawal from the society. A wife files a petition, it would be the respondent. Respondent husband should. The burden of proving a reasonable excuse shall be on the person who has withdrawn from the society. Here the husband has withdrawn, so the respondent husband shall be in the burden of proving a reasonable excuse for withdrawal from society. This is the correct answer. Which one of the following section of the Hindu Marriage Act provides void marriages? Is section 11. Section 11 provides void marriages. Section 12 is voidable marriages. Section 13 is divorce. Section 10 is judicial separation. Section 10, judicial separation. Section 13 is divorce. Section 12 is voidable marriages, and it is void marriages. Which of the section of the Indian Marriage Act is applicable for declaring a marriage null and void? Null and void if the marriage is solemnized in contravention in clause 1, 4, 5 of section 5 of the Hindu Marriage Act. It is section 11. Section 11 is talking about void marriages, null and void. It is void marriages. So section 11 is the correct answer. A marriage B, the widow of his elder brother. The marriage is valid, void, voidable. The marriage is valid, void, voidable. A marries B, the widow of his elder brother. The marriage will be void. Out of the following, which is not a void marriage? Is that at the time of the marriage, either party has a spouse. It will be a ground for void marriage. It will be under void marriage. The parties are submitters to each other. Void marriages. The parties are within prohibited degree of relationship. It is also void marriages. That either party is a bad character. This is not one of the conditions of a void marriages under section 11. So D is the correct answer. Any marriage is solemnized in contravention of the conditions specified in clause 1 of section 5 of the Hindu Marriage Act shall be voidable, null and void, irregular, and valid. Clause 1 of section 5. It is null and void. Any marriage solemnized in contravention of conditions specified in clause 1 of section 5, which states that neither party has a spouse living at the time of the marriage, it is null and void. The marriage then becomes null and void. Neither party should have a living spouse at the time of the marriage. If it is done, if A and B is to marry, if A has a wife C at the time of marriage, then the marriage would be null and void in terms of clause 1 of section 5 of Hindu Marriage Act. It will be null and void. For declaration of marriage as void, petition may be represented under section 11 of the Hindu Marriage Act 1955 by aggrieved party, opposite party, either party, or family members. It would be either of the party. Either of the party can present petition under section 11. Concealment of pre-marriage pregnancy by respondent can make marriage voidable, void, valid, or none of these. It is void. Concealment of pre-marriage pregnancy by the respondent can make marriage voidable, void, valid, or none of these. It is voidable. Suppose A is a man, he is married to B, a female. She was pregnant during pre-marriage pregnancy. She was pregnant before this marriage, but she has concealed this during the time of marriage. So the question is, concealment of pre-marriage pregnancy by the respondent by B can make marriage voidable. It is voidable. It depends upon A whether to make it void or not. So it is voidable. It depends upon the husband. So it is voidable under section 12 of Hindu Marriage Act. It depends upon the man whether to keep his wife or not. So it is voidable. A marriage solemnized between two Hindus would not be regarded as void under section 11 of the Act if one party has a spouse living at the time of marriage. Would not be regarded. It will be regarded as void. The parties are within the degree of prohibited relationship. It will be regarded as void. Either party is incapable of giving a valid consent to the marriage due to unsoundness of mind. This would be the correct answer. The parties are submitters to each other. This will also be a void marriages. Either party is incapable of giving consent due to unsoundness of mind would not be regarded as void under section 11 of the Act. If at the time of solemnization of marriage, wife has been subject to recurrent attacks of insanity under Hindu Marriage Act, the marriage will be wife has been subjected to recurrent attacks, barbar attacks of insanity are under Hindu Marriage Act, the marriage will be valid, voidable or legal. It will be voidable. It depends upon the husband to uh, it depends upon the husband whether to keep this wife or not. So it will be voidable under section 5. Under section 5, the conditions of marriage are provided. So it will be voidable under section 5 clause 2. Marital relationship comes to an end in case of a judicial separation, restitution of conjugal rights, both A and B, or divorce. It is divorce. Marital relationship comes to an end in case of divorce. The Hindu Marriage Act 1955 contains the provision regarding divorce in section 13. Section 10 is void marriages, section 11 is voidable marriages, and section 15 is about section 15. Okay, we'll see it later on. What is it? Section 15. Section 15. The Hindu Marriage Act 1955 contains the provision regarding divorce in section 10, 13, 11 or 15. It is section 13. A decree of nullity of marriage in case of voidable marriages annuls the marriages from the date of decree, from the date of petition, from the date of marriage, from the date as directed by the court. It will be from the date of the decree of nullity of marriage in case of voidable marriages is under section 11 of Hindu Marriage Act. The marriage annuls the marriage from the date of marriage. शादी के दिन से ही ये void हो जाएंगे. Suppressive marriage by a woman under Hindu Marriage Act 1955 who was pregnant at the time of marriage is ground for annulling the marriage as voidable, void, both A and B, or neither A nor B. Suppressive marriage, that is the concealment of pre-pregnancy by the bride, by the woman. The Hindus Marriage Act 1955 is a ground for annulling the marriage as voidable. It depends upon the husband whether he wants to go for divorce or not. So it is voidable under section 12 of Hindu Marriage Act. X a Hindu aged 28 years marries Y aged 25 years according to Hindu rights. It turns out that at the time of marriage, Y was pregnant by some other than X. The marriage between X and Y is illegal, void. It is voidable. Is voidable. It depends upon X whether to keep the wife or not. So it is a voidable marriage. under section 12 clause 1 subclause D, it is voidable. The nature of marriage of an important person is void, voidable, illegal, or none of these. The nature of marriage of an important person is voidable. If the person gets his importance rectified, then it depends upon the wife. So it is voidable. These are provided under section 12 of Hindu Marriage Act, and Hindu Marriage Act section 12 is providing the provision for voidable marriages. So it is a voidable. If a girl becomes pregnant by some person before marriage and subsequently marries some third person, what is the position under Hindu Marriage Act 1955? The marriage is voidable at the option of the groom. This is voidable at the option of the groom. Which is not a ground for seeking divorce under the Hindu Marriage Act 1955. Cruelty, desertion, unsoundness of mind, irretrievable breakdown of marriage. It is not the ground of divorce under Hindu Marriage Act under section 13. Irretrievable breakdown of marriage. Cruelty is a ground. Desertion is also a ground. The desertion, the minimum period shall be 2 years. Unsoundness of mind is also a ground. This irretrievable breakdown of marriage is not a ground for seeking divorce under Hindu Marriage Act 1955. Insanity is a ground for getting the marriage annulled as voidable. Judicial, it should be judicial separation, divorce, or all of the above. Insanity is a ground for getting the marriage annulled as voidable as judicial separation and divorce. It is ground for all of these. Insanity. Divorce on ground of conversion is to converting spouse, not available to both. It is not available to the converting spouse. Divorce on ground of conversion is only available to the other person who has not converted. Suppose A and B are married. B has converted to other religion. So this conversion, ground of conversion will be available to A only, not B. So it will be not available to the person who has converted, that is to the converting spouse. This ground will not be available. In case of desertion, the wife has to prove which of the following facts: the husband has abandoned her, that he has done so without any reasonable cause and against her wish and without her consent, that he has willfully neglected her. All of the above. It should be all of the above. Wife should prove that the husband has abandoned her, that the husband has done so, that is deserted her without any reasonable cause and against her wish and without her consent, that he has willfully neglected her. All this has to be proven by the wife. Under section 13 of the Hindu Marriage Act, the number of grounds for divorce which are common to husband and wife is 7, 9, 10 or 11. It is 10. There are 10 grounds which are common to husband and wife for seeking divorce under section 13. A petition for divorce with mutual consent under Hindu Marriage Act 1985 can be filed after 3 years, 2 years, 1 year or 6 months. It should be after 1 year of marriage under section 14. A petition for divorce with mutual consent can be filed after 1 year of marriage. Which one of the following provisions of the Hindu Marriage Act 1955 relates with the grounds of divorce exclusively for wife? Under section 13, there are 10 grounds which are common to husband and wife for seeking divorce. However, this section 13 clause 2 It gives some other grounds or provisions for seeking divorce which are available exclusively to wife. This is provided under section 13 clause 2. Which of the following has not yet been statutorily recognized as a theory of divorce under Hindu Marriage Act 1955? Fault theory, will theory, guilt theory, or breakdown theory? It is will theory. Has not been yet statutorily recognized as theory of divorce under Hindu Marriage Act. Will theory. Which one of the following is not a ground for divorce under Hindu Marriage Act? Apostasy, venereal disease, insanity, epilepsy. Epilepsy. This had earlier been a ground for divorce, but it has been omitted in 1999. So epilepsy is not a ground for divorce as of now. Adultery is ground under Hindu Marriage Act 1955 for judicial separation, divorce, judicial separation and divorce both. Only divorce and not judicial separation. It is judicial separation and divorce both under section 10 and section 13. The statement, while there is no roses, while there is no rose which has not thorn, but if what you hold is all thorn and no rose, better throw it away, relates to restitution of conjugal rights, judicial separation, divorce by mutual consent, irretrievable breakdown of marriage theory of divorce. It is irretrievable breakdown of marriage theory of divorce. While there is no rose which has not thorn, it is saying that all roses are having thorns. But if what you hold is all thorn and no rose, suppose you are holding roses, but what you are holding roses, but you find that these are not roses but only thorns, better throw it away. So if you are holding roses you are holding, but these are actually not roses, these are thorns, so it will be better to throw this away. It is the statement, it relates to irretrievable मतलब a relationship of marriage which cannot be retrieved, that is irretrievable breakdown. इतना ब्रेकडाउन हो गया उसमें मैरिज में, इतना मतलब वो है, परेशानी है कि उसको रिट्राइव नहीं कर सकते. दैट कैनॉट बी टर्म्ड एज ए relationship of marriage. So divorce is the best option in that case. Irretrievable breakdown theory of divorce. In which of the following reports the law commission recommended the breakdown principle to be accepted as the additional ground for divorce? It is 70th report, 72nd or 71st report. Breakdown principle to be accepted as additional ground for divorce, it is in 71st report. Venereal disease to be a ground for divorce under section 13(1)(5) of Hindu Marriage Act 1955 must be in communicable form, must be non-communicable form, must be in either A or B, that is communicable or non-communicable. Form is not relevant. The form is not venereal disease to be a ground for divorce under section must be in a communicable form. It must be in a communicable form. If the venereal disease is in a communicable form, then the ground for divorce under section 13 clause 1 subclause 5 of Hindu Marriage Act is applicable. Which of the following is not a ground for divorce under the Hindu Marriage Act 1955? respondent suffering from virulent and incurable form of leprosy, respondent a Hindu converting to Buddhism, respondent suffering from venereal disease, respondent convicted for sodomy. See, respondent a Hindu converting to Buddhism. Hindu converting to Buddhism. Buddhism is also defined as Hindu under section 2 of Hindu Marriage Act. So, this will not be a ground of conversion. Respondent a Hindu converting to Buddhism will not be a ground for divorce under Hindu Marriage Act. Option B is the correct answer. In a petition for divorce on the ground of adultery filed under section 13 clause 1 subclause 1 of the Hindu Marriage Act 1955 by wife against husband, the person with whom the adultery was committed by husband is necessary party, proper party, necessary party as well as a proper party, or none of these. The person with whom the adultery was committed by husband is a proper party. The husband is a proper party. For desertion to qualify as a ground for divorce under the Hindu Marriage Act, intention to desert is a necessary condition, a sufficient condition, neither necessary nor sufficient condition. No, it should be a necessary condition. If the desertion has taken place without the intention of the husband or the wife, then this will not fall under the ground for divorce of desertion. It is a necessary ground. The intention to desert is a necessary condition for divorce under Hindu Marriage Act. Under Hindu law, where the husband creates a condition in which the wife is compelled to leave the conjugal home and live separately, the husband may sue for divorce. The wife will be held guilty of desertion. The marriage is irretrievably broken down, or the husband is guilty of constructive desertion. Husband creates a condition in which the wife is compelled to leave the conjugal home, then the husband is guilty of constructive desertion. This is the correct option. Section 14 of the Hindu Marriage Act 1955 imposes a ban for filing petition for judicial separation, divorce, voidable marriage or void marriages. It is for filing judicial separation. Section 14 of Hindu Marriage Act 1955 imposes a ban for filing judicial separation, divorce, voidable marriage. No, it is divorce. Under section 14, it imposes a ban for filing petition for divorce. No petition for divorce to be presented within 1 year of marriage. 1 साल के अंतर में कोई भी divorce के application या petition accept नहीं करना है. In case of divorce, which of the following section of the Hindu Marriage Act 1955 provides that children of a void marriage would be legitimate children? अगर कोई शादी A and B, it is a void marriages, and a child is born to them, this marriage was void, so the child born to them would have been illegitimate, but it is legitimate as per section 16 of Hindu Marriage Act. As per section 16, this legitimacy of child, when the child is legitimate, is provided under section 16. Whether a marriage is voidable, the child has nothing to do with that. The child will always be legitimate as per section 16 of Hindu Marriage Act. In proceedings for dissolution of marriage by mutual consent under section 12B of Hindu Marriage Act, the parties have to move the court once again after 18 months of the petition, after 6 months, but before 18 months from the date of presenting the petition, after 6 months but before 12 months from the date of presenting the petition, or after 6 months but before 24 months. No, it is after 6 months but before 18 months from the date of presenting the petition. In proceedings for dissolution of marriage by mutual consent under section 12b, after presenting the petition, both the parties have to move the court once again after 6 months but before 18 months from the date of submission the or presenting the petition. This is the practice. The petition for divorce by mutual consent under section 12b may be presented according to Hindu Marriage Act 1955 if the spouses have been living separately for a period of 1 year, 2 years, 3 years, or none of this. It is after 1 year. It is after 1 year under section 13b. It should be 13b. The petition for divorce by mutual consent may be presented according to Hindu Marriage Act if the spouses have been living separately for a period of 1 year under section 13b of Hindu Marriage Act. Consent theory of divorce was introduced in the Hindu Marriage Act 1955 in the year 1956, 1961, 1976 and 1979. Consent theory of divorce, that is consent by mutual divorce by mutual consent, is inserted by Marriage Law Amendment Act 68 of 1976. 68 Amendment of 1976, and it was inserted under section 13b in the year 1976. Consent theory, that is consent theory of divorce. In Hindu Marriage Act 1951, the provision of divorce by mutual consent was added by 1976. No petition of divorce can be presented within 1 year of marriage. It is provided in which of the following sections of the Hindu Marriage Act under section 14. And section 13 is talking about provides the provision of divorce. Under section 12 it is providing voidable marriages, and under section 11 it is void marriages. So under section 14 it provides that no petition of divorce can be presented within 1 year of the marriage. Section 16 of Hindu Marriage Act does not confer status of legitimacy to children born out of a valid marriage, out of a voidable marriage, out of a void marriage, or without marriage. It confers status of legitimacy to children born out of valid marriages, out of a void marriages, or out of a voidable marriages, but it does not confer status to legitimacy of children born without marriages. So option D is the correct answer. It confers status of legitimacy to children born out of a valid marriages, a voidable marriage, or a void marriage, but it does not provide status for a children born without marriage. Under which section of Hindu Marriage Act husband and wife are allowed to divorce by mutual consent? Under section 14. No, under section 13b. Section 14 provides that there will be no application for divorce will be made within 1 year of marriage. So it is section 13b, divorce by mutual consent. Section 13b is the correct answer. It is inserted by 68th amendment of in the year 1976. Can suit lie in the civil court for obtaining the decree for annulment of a Hindu marriage after the death of spouses? No, the suit will lie. Yes, the suit will lie. Depends. None of the above. Obtaining the decree for annulment of Hindu marriage after the death of the spouses? No, the suit will not lie. खत्म हो जाएंगे मरने के बाद. So it will be no. Under Hindu Marriage Act, condonation applies to the matrimonial offense of adultery, cruelty, desertion, both A and B. It is adultery. Condonation applies to matrimonial offense of adultery. Which of the following theories is the outcome of a fundamental shift in the policy discernible from the judicial recognition of the view that the purpose of divorce law was not to punish the guilty but to protect the innocent spouse? It is fault theory, consent theory, breakdown theory, both A and B. It is breakdown theory. The judicial recognition of the view that purpose of divorce law was not to punish the guilty but to protect the innocent spouse. It is the breakdown theory. Consider the following. A Hindu widow who had inherited property from her father-in-law dies issueless intestate. मतलब this father-in-law had no ancestors, had no son or daughter, issueless, and dies intestate without a will. The property shall devolve upon the husband, the mother and father, the heirs of the father, the heirs of the husband. It should be the heirs of the husband of the widow. एक आदमी थे F, इनके ना बच्चे थे. Sorry. A Hindu widow. It's a Hindu widow. She has got some property, inherited property from her father-in-law. Father-in-law के पास से इनके पास आया inherited property. But this lady dies issueless. इनका कोई बच्चा नहीं है, कोई भी बच्चा नहीं है, and intestate without any will. The property shall devolve upon the husband, the mother and father of husband तो है ही नहीं, the mother and father किसके, wife के, इनकी mother and father, the heirs of the father, the heirs of the husband. heirs of the father मतलब जो इनका husband थे उनका fathers या था heirs of the husband. किसको मिलेंगे? It will be to the heirs of the husband because this property has been inherited to this wife from the heirs of the husband. So this property shall devolve upon the heirs of the husband. The heirs of the father मतलब इस widow के जो father थे उनके heirs. No, the heirs of the husband devolve. The property shall be devolved upon the heirs of the husband. A is a Hindu male. D, he dies intestate, leaving a son. B, A is a Hindu male. He dies intestate, leaving a son. B, two grandson M and N, of deceased son C. ये क्या है? C के बेटे थे. And three grandsons X, Y, Z of deceased grandson P. P के X, Y, Z of deceased son D. D जो है D के बच्चे थे P के बाद क्या हुआ? X and Y हुआ, X, Y and Z हुआ. What will be the share of M and X? 1/3, 1/6, 1/6, 1/9, it shall be, what will be the share of m and x? m and x का पूछा है, m कहाँ पे है, यहाँ पे है, and x कहाँ पे है, x यहाँ पे है, तो it will be 1 2 3 4 5 and 6, 1/6 and उसके बाद में it will be 1/9, m के लिए आएगा 1/6 and x के लिए आएगा 1/9. This is the correct answer. Application for maintenance can be made to trial court, appellate court, high court, supreme court. Trial court. Application for maintenance can be made under section 28 of the Hindu Marriage Act to trial court. Which section of Hindu Marriage Act deals with alimony? Section 24, 21, 26 or 36? See, section 36 is not available in IPC. Hindu Marriage Act. So section 24 is Act deals with alimony. Section 24. Section 21 provides the application of Act of SIBE. Application of Act of 5 of CRPC 1908. It talks about the applicability of Act of 5 of CRPC 1908. Section 24 talks about, provides the provision of alimony. In section 26, it provides the provision for custody of children. So section 24 deals with alimony and section 25 deals with permanent alimony. Section 24, it deals with alimony, but section 25 deals with permanent alimony. So section 24 is the correct answer over here. Section 24. Under section 19 of the Hindu Marriage Act 1955, a petition in a matrimonial case has to be filed in the place where the marriage was solemnized, at the place where the respondent at the time of the presentation of the petition resides, at the place where the parties to the marriage last resided together, or all of the above. It can be filed anywhere where the marriage was solemnized, at a place where the respondent at the time of the presentation of the petition resides, or at the place where the parties to the marriage last resided together. All of the above is the correct answer. Maintenance pendant light under section 24. Act can be granted to the wife, the husband, either the wife or the husband. It can be granted to anyone. Maintenance pendant light, that is maintenance during the pendency of the case and expenses of the proceeding under section 24, that is temporary alimony of the under the Hindu Marriage Act, can be granted to either the wife or the husband. The proceeding in a case shall be in camera, matrimonial, maintenance, testamentary and intestable succession, or all of the above. Under section 22 of Hindu Marriage Act, the proceedings of matrimonial cases shall be in camera. Under section 22. Interim maintenance claimed by husband or wife during pendency of matrimonial proceedings is called as maintenance pendant light, alimony pendant light. Receivings, none of this. It is maintenance pendant light under section 24 of Hindu Marriage Act. Maintenance pendant light. A Hindu male can claim maintenance from his wife under section 24 of Hindu Marriage Act. Okay. Section 18 of Hindu Adoption and Maintenance Act 1956. Section 125 of Code of Criminal Procedure, or none of the above. A Hindu male, it is talking about a Hindu male. A Hindu male can claim maintenance from his wife under section 24 of the Hindu Marriage Act, that is maintenance pendant light during the proceedings of the case. A husband can claim maintenance. These are the grounds where wife can claim maintenance. Section 18, section 24, 18, 125. In all these cases, wife can claim maintenance from husband. But this is the only exception that under section 24 of the Hindu Marriage Act, a husband can claim maintenance from his wife. Section 26 of the Hindu Marriage Act, as amended by the Hindu Marriage Amendment Act 1964, deals with custody of children, disposal of property, maintenance pendant light, no. Permanent alimony, no. Disposal of property, it is also no. Custody of children, it is custody of children. It talks about the custody of children. Section 26 of Hindu Marriage Act, it provides the provision of custody of children. It confers the status of the legitimacy of the children. All these are provided under section 26. A petition under this act cannot be presented to the district court within the local limits of whose original civil jurisdiction, where the marriage cannot be presented to the district court within the local limits of whose original jurisdiction, where the marriage was solemnized. The respondent at the time of presentation of the petition resides. The parties to the marriage did not last reside together. The petitioner wife is residing at time of the presentation of the course. It should be the petitioner, the parties to the marriage did not last reside together. It cannot be presented to that court, district court, where the party did not last reside together. This is under section 19. This petition can be presented to the district court where the marriage was solemnized first, or where both the parties had lived together. Petitioner wife is residing at the time of respondent at the time of petitioner of the resides, where the husband or the wife is residing, or where they both lived together. The parties to marriage did not last reside together. There you cannot file this petition. So the parties to the marriage did not last reside together. You cannot present the application, the petition, the district court within the place where the parties to the marriage did not last reside together. What is the consequence when the age of Hindu girl at her time of marriage under Hindu Marriage Act is less than 18 years? The marriage is valid but punishable. The marriage is void. The marriage is invalid. The marriage is illegal. The marriage is valid but it is punishable. The girl at the time of her marriage was below 18 years. This doesn't invalidate the marriage, but it is punishable. Under section 28 of the Hindu Marriage Act 1955, every appeal from decree or order shall be preferred with effect from 23rd of December 2003 within a period of how many days from the date of decree and order? It is within 90 days, that is 33 months. Under section 28, every appeal, if there is an appeal, it shall be preferred within 90 days from the decree or orders with effect from 23rd of December 2003. Alimony under section 25 of the Hindu Marriage Act 1955 can be ordered by a civil court, a court exercising jurisdiction under Hindu Marriage Act, both A and B, or neither A or B. It is a court exercising jurisdiction under Hindu Marriage Act. Alimony under section 25, that is permanent alimony. It is a court exercising jurisdiction under Hindu Marriage Act. Under a Hindu law, in relation to the children of void marriages, a court declaration is necessary to confer a status of legitimacy. A court declaration is not necessary to confer a status of legitimacy. Such a child becomes legitimate after reaching the age of 18 years. Such a child cannot become legitimate. In relation to the children of void marriages, a court declaration is necessary. A court declaration is not necessary, or such a child becomes legitimate after reaching the age of 18, or such a child cannot become legitimate. No, a court declaration is not necessary to confer a status of legitimacy under section 26 of the Hindu Marriage Act. A relation, a child born to a void marriages is legitimate. A court declaration is not required. Divorced person can marry again under provisions of section 15 of the Act. Okay, section 15, it is talking about remarriage. Provision of section 15 of the Act: if the marriage has been dissolved by a decree of divorce in case the time period for preparing an appeal against the decree of divorce has expired without preparing the appeal. The appeal which was presented against the decree of divorce has been dismissed. The appeal preferred against the decree of divorce is pending. There is no right of appeal against the decree of divorce. Divorced person can marry again under the provision of section 15 if the marriage has been dissolved by a decree of divorce in case the appeal preferred against the decree of divorce is A and B were married. They put up a petition for divorce. Decree of divorce has been declared, or there was a decree of divorce. Marriage has been dissolved. Now, divorced person, they can marry after the time period for preparing an appeal against the decree of divorce has expired without preparing the appeal. If there were no appeal and the time for preparing the appeal has expired, they can marry. So is the correct answer. And this appeal shall be preferred within 90 days from the date of decree of dissolution of marriage. The statutory bar: no petition to be presented within 1 year of marriage under section 14 of the Hindu Marriage Act 1955 is imposed on petitions for divorce. It is only for divorce. As a rule, a petition for dissolution of marriage under Hindu Marriage Act cannot be presented before the expiry of from the date of marriage. A petition for dissolution of marriage under Hindu Marriage Act 1955 cannot be presented before the expiry of from the date of marriage. It should be 1 year. Adultery is a ground under Hindu Marriage Act for judicial separation, divorce, judicial separation and divorce both. It is judicial separation and divorce both under section 10 and section 13. A Hindu dies intestate, leaving a son and 2 daughters. His property was partitioned. Whether each one of the successors is entitled to alienate his or her share without the consent of the other heirs? Yes. Died intestate, leaving a son and 2 daughters. That is total 3. His property was partitioned. After partition of the property, each successors is entitled to alienate his or her share without consent of the other heirs. Yes, it is correct. Lastman Uttam Chand Kriplani versus Meena is the leading decision of the Supreme Court on the ground of cruelty, desertion, insanity, or adultery. It is desertion. Leading decision of the Supreme Court on the ground of desertion. A remarriage within 5 days of passing of the decree of annulment of marriage under Hindu Marriage Act 1955. Is the marriage void, valid, voidable, or illegal? The marriage is void. A remarries within 5 days of passing of a decree of annulment of marriage under Hindu Marriage Act. Is the marriage void, voidable, illegal, or valid? It is a valid marriage. It is valid. Passing of a decree of annulment of marriage. That is, the marriage is dissolved and it is valid marriage. A has married after dissolution, decree of annulment of marriage. It is valid marriage. The principle that subsection 2 of section 14 is more in the nature of a proviso or exception to subsection 1 was laid down in Karmi versus Armu, Tulasamna versus Shesha Reddy, Balwant Singh versus Daulat Singh, and Nazar Singh versus Jagjit Singh. The principle that subsection 2 of section 14 subsection was laid down in, that is, that within the period of 1 year of the marriage, no application, no petition shall be filed for divorce. The exception to subsection 1 was laid down in Nazar Singh versus Jagjit Singh. According to court rulings, custody of a Hindu child up to the age of 5 years shall ordinarily be with the father, sister, grandfather, or mother. It is with the mother. Child up to the age of 5 years shall be ordinarily with the mother. A born Muslim girl brought up in a Hindu orphanage married a Hindu boy as per Shastric rites. The marriage is valid, invalid, voidable at the opinion of the option of the girl, voidable at the option of the boy. It is an invalid marriage. It is an invalid marriage as per Hindu Marriage Act. G. A Hindu girl. G. A Hindu girl aged 14 years marries B. A Hindu boy simply by exchange of garlands in a temple in Delhi. Later on, G finds that B is important. Okay. G leaves the matrimonial home and marries A. In the following situation, G can be punished for bigamy. G cannot be punished for bigamy. G cannot be punished for bigamy because her first marriage was not valid on account of improper solemnization of marriage. Or G cannot be punished for bigamy because her first marriage was not valid on account of impotency of B. Simply by exchange of garlands. No, G cannot be punished for bigamy because her first marriage was not valid on account of improper solemnization of the marriage. So, G cannot be punished for bigamy. This is the correct answer. Order of permanent alimony under section 25 of Hindu Marriage Act can be varied, modified, or rescinded if the party in whose favor the order has been passed remarries. Okay. If the party in whose favor the order has been passed is the wife, she has not remained chaste. Or if the party in whose favor the order has been passed is the husband and he has had sexual intercourse with any other woman, it is all of the above. When a order is there for permanent alimony under section 25 and in whose favor, suppose A and B were married and order of the court was for permanent alimony to B was there and B has remarried, then permanent alimony can be varied, modified, or rescinded. If the party in whose favor the order has been passed is his wife, and she has not remained chaste, she has entered into some activities that this can be rescinded. And if the party in whose favor the order has been passed is husband, अगर ये husband है and he has sexual relations or intercourse with any other woman, then the permanent alimony can be alteration to permanent alimony order of permanent alimony can be done by the court. This is all of the Dastana versus Dastana is a case on adoption, divorce, marriage or maintenance. Dastana versus Dastana is a case of adoption, divorce or Dastana versus Dastana is a case on divorce, and the case was on cruelty. It is a very famous case. Famous case of cruelty on divorce. Divorce is the answer. Divorce on the ground of cruelty. Dastana versus Dastana. Bar to entertain a petition for for divorce is contained in Section 14 of the Hindu Marriage Act, Section 15, Section 19 or Section 23. It is Section 14 of Hindu Marriage Act. Section 15 provides the remarriage of divorced person. Section 19 provides courts to which petition shall have to be filed. Courts to which petition for divorce or judicial separation has to be filed on. Section 23 is decree in proceedings. So Section 14 provides bar to entertain a petition for divorce. That is, no one can file petition for divorce within 1 year of marriage. During judicial separation, the parties continue to be husband and wife, but marital rights and obligations are suspended. Parties continue to be husband and wife, and the marital rights and obligations remain intact. Parties continue to be husband and wife, and other rights and obligations are suspended. Parties ceases to be husband and wife. During judicial separation, parties continue to be husband and wife, but marital rights and obligations are suspended. In Bipin Chandra versus Prabhavati, the Supreme Court explained the concept of cruelty, the institution of marriage, the concept of desertion, the concept of adultery as applicable under Hindu Marriage Act. It is Bipin Chandra versus Prabhavati, the concept of desertion. Which of the following prerequisite is not a ground for judicial separation of a marriage? Cruelty, bigamy, suffering from venereal disease, or demand for dowry? It is demand for dowry. It is demand for dowry under Section 10. It should be read with Section 13. What is the effect of judicial separation on material relation? It should be marital relation under Hindu Marriage Act. Marital judicial separation. Marital relations come to an end? No. The marital relations is suspended. During judicial separation, the marital relations is suspended. A Hindu couple having the decree of judicial separation wants to live together. They can live together. They cannot live together. They can live together only after the permission of the court. Yes. They can live together, but only after the permission of the court. If during the period of judicial separation either spouse indulges in adultery, does it furnishes a ground for divorces? It is a repeated question. Yes. is a ground for divorce. The special grounds of divorce and that are available to the wife only are given under section 13(2) of Hindu Marriage Act 1952. This section 13(2) of the Hindu Marriage Act. Special grounds for divorce for wife is provided under this section. Which one of the following is not a ground for divorce under Hindu Marriage Act? Apostasy, it is also a repeated question. Epilepsy, this has been omitted in the year 1999, so it is not a ground of divorce as of now. The offense of custodial rape is introduced in the Indian Penal Code after protests on decision given in Imrana case, Mathura case, Shah Banu case, or Nanavati case. The offense of custodial rape is introduced in the Indian Penal Code after protest on the decision given in the Mathura case. For desertion to qualify as a ground for divorce under Hindu Marriage Act, the intention to desert is a necessary condition. It is a repeated question, but it is a necessary condition. The intention to desert is a necessary condition. Which one of the following is a correct statement? Divorce by mutual consent has been provided under the Hindu Marriage Act from its inception. Divorce by mutual consent was introduced by Hindu Marriage Act 1976, Amendment Act 1976. Divorce by mutual consent has been provided under section 13A of the Hindu Marriage Act. A petition for divorce by mutual consent must be presented within 1 year of marriage. This is correct. Divorce by mutual consent was introduced by Hindu Marriage Amendment Act 1976. This statement is correct. All others are wrong. Divorce by mutual consent has been provided under section 13A. It is wrong. It is 13B. So, divorce by mutual consent was introduced by Hindu Marriage Amendment Act 1976 is the correct answer.